And the anti-AI people have just been doing victory laps all over the socials about the settlement in Bart's v. Anthropic. The first thing to know is, there is no settlement yet. The judge has to sign off on it, and he has serious misgivings. More on that later. The second is that settlements aren't precedential. They don't have any sort of effect on other cases, although they're often used by bullies to sue other people and companies and force them to settle even absent all the merits. But you'd never know that to hear the neo-Luddite copy bullies who insist that this means that AI is absolutely 100% theft for all time, while at the same time claiming that two separate district court judges ruling that it's fair use means absolutely nothing. Brandon Butler of Recreate posted a good analysis of why this settlement wouldn't mean much even if it does go through. Quote, "The copyright cartel celebrated the deal, and some suggested it was proof that AI training requires a license. That framing obscures a key fact. Anthropic had already won on the question of whether AI training was a fair use." Exactly! And it wasn't even close. It was, in the words of the judge, quintessentially transformative, spectacularly so, the most transformative any of us are likely to see in our lifetimes. And that's his first point, that it has nothing to do with fair use. Quote, "Judge Alsop was clear that AI training is fair use. He found that training AI models is spectacularly transformative, and further determined that acquiring print copies on the used book market and digitizing them for the purposes of AI training is also fair use. That ruling was not impacted by the settlement." Yeah, but it was kind of negated. The cartel is screeching, "But my piracy!" and complaining about the mass downloading. But if the ultimate use is fair, it shouldn't matter how you got it. That's a fairly well settled issue that's being abrogated here. Quote, "The settlement doesn't set a precedent for anything, but especially not for licensing AI training. This private settlement cannot bind anyone but these two parties, and Judge also ruled that a market to license AI training is not one the Copyright Act entitles authors to exploit." One thing he's missing, though, this is a class action lawsuit, and that's a big issue, because not only do we not know who the class members are, and unusually the onus is on Anthropic to figure that out somehow, but they'd all be different, with different deals with their publishers, different levels of damage and exposure, and so on. But again, more on that later. Quote, "Copyright's exorbitant statutory damages provisions were likely much more important than the merits in driving Anthropic to settle. This creates a potential death sentence even for a leading company like Anthropic. The amounts involved in this settlement are thus not a reflection of the true market value of copyrighted content in the age of AI, but rather a windfall to these plaintiffs extracted in the shadow of draconian statutory penalties." And as I pointed out on my YouTube channel, this is how they bully you into a settlement absent the merits. This is a huge problem with the system. Quote, "Even the data sourcing question at the heart of the settlement remains wide open. Within days of Judge Alsop's ruling excoriating Anthropic for using shadow libraries, another federal court ruled exactly the opposite. In Cadre v. Meta, Judge Chabria reasoned that fair uses are always unauthorized, so the use of unauthorized copies should be permitted when the ultimate purpose is fair. The plaintiffs in the Anthropic case were aware of this opinion and knew they might end up losing on appeal. That's why they settled. If the case was a slam dunk for them, they could have continued to litigate in pursuit of those sky-high statutory damages. And if you followed my coverage, you know that Anthropic had an interlocutory appeal up to the Ninth Circuit that they were in an extremely good position to prevail on. That means that, if anything, this settlement wasn't at all about Anthropic admitting defeat, but the plaintiffs settling for an amount much lower than the standard liability in order to avoid a court ruling invalidating everything. Butler concludes, "Mistaking this one-off private settlement for a blueprint for AI licensing requires twisting the facts and ignoring the actual rulings in this case. It's understandable that companies and policymakers are hungry for guidance on these important issues, but they should look to the rulings themselves for that guidance, not to private arrangements extracted under threat of heavy penalties. And it's not only the companies who want guidance. Judge Alsop himself does. He sent an order with 4 pages of questions for the preliminary approval hearing on September 25th. I won't go over them all, but they're questions like, author and publisher file a joint claim providing adequate documentation of their beneficial and legal ownership of the right to reproduce copies and stating that they have reached agreement on how to split their award. One of 3 authors of a single work opts out, while the others file claims to participate, as does the publisher. All the claimants, but not the absent author, have reached an agreement as to how to split the award. As a variant, 2 of 3 opt out. 1 later requests re-inclusion. Upon receiving notice of the re-inclusion request, the 3rd wishes to re-include. A claimant is paid only to be sued later by an author or publisher seeking its share of the recovery. What provisions of the notification and claims processes, or otherwise including case law, would bear on whether or not any such collateral actions could be brought, and, if brought, on how they could be decided. Suppose that while the author and publisher have retained beneficial and legal ownership of that right, a movie studio has acquired the exclusive legal right to prepare derivative works. Does this mean that the movie studio is not in the class and therefore has not given up its potential claim against Anthropic, one turning on its contention that Anthropic created derivative works? And so on. Individually, these might be taken to be technical details, but there are 17 of these all total, and taken together, they really show what a mess this class action suit is. In fact, it really shows why many experts feel there shouldn't be any class action copyright lawsuits at all. Class actions really only work when class members are all the same. When they're as diverse as this, with damages at different levels and spread out against multiple parties? Entire lawsuits have hinged on the rights of a single book or song. Doing this for all the class members when we don't even know who they are? The judge is showing serious misgivings about this settlement, and so should you. And once again, understand the motivation, not to mention the willingness to ignore reality, of all of the anti-AI copy bully Luddites who keep using this as a club to beat us over the head with.